Good afternoon. A very warm welcome to all of you, distinguished participants, both physically here in Hanoi and also online. On behalf of the Diplomatic Academy of Vietnam, the co-organizer of this online event, together with the Mitsubishi UFG Research and Consulting, I would like to welcome you all to this webinar on the necessity of maintaining international law-based order in the East and South China Sea. I would like to particularly welcome Professor Susumu. Very good to see you again, Susumu-san, the president of the Security Strategy Research Institute of Japan, to this webinar. It's a long time we haven't seen. I wished you were here with us in Hanoi, but it's good to see you online, Susumu-san. I'd also like to welcome Ms. Yurika Ishii, Associate Professor at the National Defense Academy of Japan. Welcome to the webinar. I'd like to also welcome our distinguished speakers on our end here in Hanoi, Associate Professor Dr. Nguyễn Thị Lan Anh, Director General of the East Sea or South China Sea Institute of the Diplomatic Academy of Vietnam. I especially like to welcome Ambassador Nguyễn Thị Thanh Hà, former Director General of the International Law and Treaty Department of the Ministry of Foreign Affairs and Vice General Secretary of Vietnam Society of International Law. To all, from all of us, both here and online, a very warm welcome to our distinguished speakers today. Today's seminar is going to be on the necessity of maintaining international law-based order in the East China Sea and South China Sea. We have gathered 4 distinguished speakers who are going to help us understand the challenges that we are facing in the East China Sea and South China Sea, and the ways forward to maintaining the international law-based order in both of the seas. The East China Seas and South China Seas, despite being separated, but present 2 very similar problems. And that is the challenge of maintaining the international law-based order there. They are, although separated by geographical distance, they are facing common challenges stemming from geopolitical tension between the major powers, from growing assertiveness and expansionism from certain major powers, and from rising challenges to maritime securities, such as navigational rights, such as other non-traditional challenges as well. All of these challenges are posing increasingly difficult challenges for littoral states, as well as the international community, to maintain the international rules-based order there, and also overall peace and stability in both of the region. Now, Japan and Vietnam are very important partners. Despite the geographical distance, again, the 2 countries' ties have been ever growing. Vietnam and Japan have just recently upgraded their bilateral relationship to a comprehensive strategic partners, whereby maintaining security and maritime security in particular is of both countries' interest. In the recent visit by Vietnam President to Japan, both sides reiterated the importance of maintaining free and open Indo-Pacific. I shall quote a little paragraph from the joint statement agreed upon by our 2 leaders. Prime Minister Kishida affirmed that Vietnam and ASEAN are important partners for Japan to realize a free and open Indo-Pacific, and that Japan stands ready to support Vietnam and ASEAN, including within the framework of the ASEAN Outlook on the Indo-Pacific and the implementation of the joint statement between ASEAN and Japan on the outlook on the Indo-Pacific. President Thương also appreciated Japan's continuous support for the AOIP, which shares relevant fundamental principle in promoting peace, cooperation with Japan, free and open Indo-Pacific vision. So I assume that this webinar which is to focus on maintaining the international rules-based order, fits very well in our leaders' common aspiration to maintain a free and open Indo-Pacific. So without any further ado, let us begin the webinar. We shall have two sessions. Session one is going to talk about the challenges to the international rule-based order in the East and South China Sea. We will have two distinguished speakers on this panel. The first speaker would be Mr. Takai Susumu, President of the Security Strategic Research Institute of Japan. And the second speaker would be Professor Lan Thị Nguyen, Director General of the South China Sea Institute. After that, we shall have a little break before we resume the second session, which is going to discuss the way forward, where we will have, again, two speakers, one from Japan, Ms. Yurika Ishii, and Ambassador Nguyễn Thị Thanh Hà. So let us now move directly to session one, and I have the honor of inviting Professor Takai Susumu to be the first presenter. Professor Susumu-san, you have the floor.
Yes, the content of my presentation can be seen on this slide. Firstly, I'd like to talk about the general principle of international law, which is the base of international order. Next, I will examine Russia's military aggression to Ukraine and international evaluation as a case of the unilateral changing the status quo by force. Then, I will examine the actual state of China's attempt to unilaterally change the status quo by force in East Asia. And finally, I will explain the need for countries with the same values to cooperate and defend the international order based on the law in response to warfare diplomacy in South and East China Sea. Next slide, please. The role of international law is to maintain the law and orders in international relations. That is to ensure the role of rule of law. The Westphalia in 1648 was a peace treaty that ended the 30-year war among the Christian countries. The treaty recognized each lord's current territory as a sovereign, while the retained the armed forces and entrusted them with the control of their own armed forces. Since then, international law has determined the rule among the nations and the utilization of international public space. Countries that have agreed to international law have an obligation to comply with that international law. In other words, the agreement must be kept. Pacta sunt servanda. Next slide, please. Another role of international law is to provide a peaceful means of conflict resolutions in international relations. Namely, based on Article 2 of the United Nations Charter, member states of the United Nations are obliged to refrain from the use of force and to settle international disputes peacefully. Therefore, at least the United Nations member states must clearly recognize that any attempt to unilaterally change the status quo by force is the United Nations Charter shows member states to use force only in 3 cases, such as United Nations military sanction, resolution stipulated in Article 43, the right of self-defense stipulated in Article 51, and the resolution authorizing the use of force, which is a basis for the sanctions of multinational forces. Russia's armed invasion of Ukraine was clear violation of international law. Russia's rationale for using force was that Ukraine is a brotherly country and to counter NATO's eastward expansion. However, there was no armed against Russia from Ukraine. The fact that a permanent member of the United Nations Security Council openly used force against another United Nations member state shocked the international community. Russia's action made paralyze the United Nations Security Council, which mission is to maintain the international peace and order. Next slide, please. Evaluation of the Russia's action in the violation of international order were divided into two patterns, such as the countries that insisted violation of international law and those that did not, and those that insisted it was a unilateral attempt to change the status quo by force, and those that did not. China's assessment is that the presence of the United States in the case of such actions, and that the greatest responsibility lies with American hegemony. In addition, India's assessment was that Russia was not responsible for the invasion of Ukraine. North Korea provided arms support to Russia. Next slide, please. The UN Security Council was unable to adopt the immediate ceasefire resolution as a permanent member. Russia and China exercised their veto. Since then, the UN Security Council has not been able to adopt the necessary resolutions regarding the Russian-Ukrainian war. The list of the resolutions shown in this slide were adopted by the United Nations Security General Assembly. Looking at the voting results for these resolutions regarding Russia's invasion of the law-based violation of the law-based international law order, you can see that there were many negative votes, abstentions, and no votes. This division of international value showed that the free and open international order based on law has been fragile. It can be said that countries that share the same values must work together to protect the international order based on law. Next slide, please. Let us focus on the current state of the breaking the international law order based on the law in East Asia. China's economic policies, such as One Belt, One Road, and the Asian Development Bank are against economic interests of the United States of America. Furthermore, China claims to secure maritime rights and interests in South and East China Sea, and China's cross-border diplomacy threatened the maritime rights and interest of the neighboring countries in these areas. I'd also like to comment on China's legal warfare, yes, which is one of China's foreign policies. China's legal warfare is to arbitrarily interpret international law and enact domestic law, and use China Coast Guard to force foreign countries to comply with Chinese domestic law. This policy is to demonstrate the legitimacy of China's use of force. Furthermore, it is a policy to avoid interference from the third countries asserting China's illegality. And it is also a policy to avoid criticism from the Chinese people regarding China's democratic dem- diplomatic stance. Next slide, please. Okay, China's goal in South China Sea is to change the South China Sea as Chinese Sea. As early in the 1974, China used force to acquire the islands of Paracel Islands, which was being occupied by Vietnam. In 1985, China also used force to seize 6 atolls in the Spratly Islands of Philippines. China ratified the United Nations Convention of the Law of the Sea in 1996, and in 1998 enacted a domestic law established a 2,000 nautical miles EEZ and continental shelf in the waters surrounding the islands and atolls in the South China Sea. China claims the South China Sea as one of the core interests, along with the Taiwan, Tibet, and Xinjiang Uyghur in 1929. In 2014, it created the artificial island on 6 atolls and used them as a military base. U.S. Navy vessels have been conducting the FONOPS since 2015 to ensure freedom of navigation. Chinese Coast Guard ships and fishing boats manned by maritime militia have harassed the U.S. Navy vessels. Last year, China Coast Guard ships fired water guns at the Philippines supply ship resupplying to Second Thomas Atoll of Philippine territory, and the supply ship was sunk along with the Coast Guard ship. Next slide, please. China's portfolio diplomacy in the East China Sea is as follows. Japan incorporated the Senkaku Island into territory in 1895 based on the territorial possession of the terra nullius under international law. In 1971, China suddenly began claiming the Senkaku Island as the Chinese territory. And in 2010, a Chinese ship boat entered the water around the Senkaku Island and rammed a Japan Coast Guard ship. In 2012, China publicly stated that Senkaku Islands are China's core interest, and in 2013, China established an air defense identification zone, ADIZ, over the Senkaku Island. In 2020, Chinese Coast Guard ships equipped with a 76 millimeters cannon appeared in the waters around the Senkaku Islands. And in 2023, China set up floating buoys in the EEZ around the Senkaku Island. China has gradually expanded jurisdiction and continues to attempt to unilaterally change the Senkaku Islands into the Chinese island by force. Next slide, please. China will never give up on using force to obtain its core interest. Russia's use of force against Ukraine and its international reputation must have given China confidence to unify Taiwan by force. President Xi Jinping made a clear intention to unify Taiwan at the 2023 Communist Party Congress, which approved the third term of the Xi Jinping administration. President Xi Jinping also expressed the possibility of the unifying Taiwan by force. He appeared in his speech on December 31, 2023, last year, that the unification of Taiwan is a historical necessity. Next slide, please. Thus, it can be said that the security environment in East Asia is worsening due to China's exercising the war warrior diplomacy. A collision between China Coast Guard ship and foreign Coast Guard ships could escalate into a regional armed conflict. Furthermore, given the victory of the Democratic Progress Party in Taiwan's presidential election in January 2024 this year, China may use military forces to unify Taiwan in near future. Countries must recognize the fragility of the law-based force, free and open international order in the region. These countries must also share information about China's warrior diplomacy in East, South, and East China Sea, and jointly counter China's attempt to unilaterally change the status quo by force. Like-minded countries which share the same value should have established a mechanism to defend a free and open international order based on law in East Asia. Thank you very much for your attention.
Well, thank you very much, Professor Susumu-san, for a very comprehensive presentation, recalling the challenges to the rules-based order that both South China Sea and East China Sea faced. And we can see very similar pattern that occurred in the two seas. That shows the two seas are connected not only by the maritime sphere, but also by its similar challenges and similar actors that are challenging the rules-based international order in both of the seas. Let me now invite the second speaker. I would like to turn over to Professor Nguyễn Thị Lan Anh, Director General of the South China Sea Institute of the Diplomatic Academy of Vietnam. Professor, you have the floor.
Thank you, Mr. Chairman. Distinguished participant on site in the DAV, as well as participant online with us on the seminar today. I'd like to address the topics of challenges to the international rules-based order in the East and the South China Sea. Normally, international rules-based order will require the every party act in accordance with international law, and also require the party to interpret and implement international law in good faith. We already hear Professor Takai talk about the principle of Pacta Sunt Servanda. It is one of the main principles govern the implementation of treaty and also international law. When it comes to the South China Sea and the East China Sea, we would like to recall what are the sets of rules that govern the both of the oceans. First of all, according to Article 38, Paragraph 1, when we often refer to as the sources of international law, there are four main sources. First one, international convention or international treaty. We often talk about the general principle enshrined in UN charters that Professor Takai already mentioned. Some of the principle, which is the prohibition of the use of force or threaten to use of force. We also have the United Nations Convention on the Law of the Sea, 1982, which usually referred to as the Constitution of the Oceans in the world. In some specialized areas, we also have a number of IMO conventions, and especially nowadays when we are talking about the importance of marine environment, we are talking about the obligation under the international treaty that govern marine environment protection. Second source is when it comes to customary international law, we are talking about the set of rules that already recognized widely on territorial acquisition. The principle that enshrined into the UN Charter, namely the prohibition of the use of force or peaceful dispute settlement, already widely recognized in case law as well as in state practice as customary international law. And also, many parts of UNCLOS has been recognized as customary international law. We are talking about general principles of law at the third source of international law. And here we hear again the principle of pacta sunt servanda. And finally, as the supplementary sources of international law, when Article 38 refers to judicial decision and the teaching of the most qualified publicists, here in the South China Sea and the East China Sea, we have the most relevant ruling of the arbitration in 2016, awfully recalled in the short name as the South China Sea arbitration. So given all these sources of international law we have in mind, we believe that how to promote international law in order to build good order at the South China Sea and the East China Sea. I believe that first, every party need to interpret and implement in good faith. And whenever the dispute arises between the party need to follow the principle of peaceful settlement, that whatever means offered by international law, Professor Takai already mentioned the list under Article 33 of the UN Charter, ranging from negotiation to judicial measures, and those recognized as a peaceful means, and finally, promoting cooperation. What has been done in order to promote the rule-based order in the East and the South China Sea? We believe that in addition to the good faith in interpret and implementing the rules-based order, we also need to avoid unilateral and arbitrary interpretation of international law. We also need to avoid the coercion or the use of force. But in fact, in the South China Sea and the East China Sea, we have all the opposite practice. First, we have the popular practice of twisting or cherry pickings in interpreting UNCLOS concept. In 2009, it was the first time China introduced the 9-dash line map to the UN under a note verbal. And in that note verbal, China tried to claim the sovereignty over the adjacent water and sovereign right and jurisdiction over the relevant water. If we read the phrase, we will find that sovereignty usually referred to internal water and contiguous and territoriality under UNCLOS. And sovereign right and jurisdiction often refer to contiguous zones, EEZ, and continental shelf. However, here China tried to twist the concept by using sovereignty over adjacent water and sovereign right and jurisdiction over the relevant water. In 2016, in reply to the South China Sea arbitration judgment or award, China tried to advocate for the so-called four-share claims when it tried to elaborate that it have sovereignty over non-high shootout. Accordingly, China have internal water, territorial sea, EEZ, and continental shelf based on the 4 groups of islands in the South China Sea. Actually, the legal regimes of islands, that mean how many maritime zones that an island can have or can generate, has been provided under UNCLOS. And the Arbitrary Tribunal Award 2016 already declared that all the geographical features of the Spratly have no more than contiguous zones. It are required as a rock regime. Nothing to say if China believed that the interpretation of Arbitrary Tribunal Award inconsistent with its practice and its claim. However, it's noteworthy to mention that China followed the cherry picking approach because in the South China Sea, China would like to turn all the feature into the 4 maritime zone island, whereas in the East China Sea, China would like to apply the rock concept to the island claimed by Japan. When it comes to coercion or the use of force or threaten to use of force, we also see a kind of similarity in situation in the South China Sea and the East China Sea. The chart on your left-hand side show the increase in number of military exercise in the South China Sea conducted by China, whereas the map on your right-hand side show the increase in tendency of the variety of activity, military activities in not only the East China Sea, but also expand to the Sea of Japan. All the arrow mark in yellow indicates the frequencies of the military activity of China in the Sea of Japan as well as the East China Sea. And it seemed like every strait, every maritime route between islands controlled by Japan has been frequently used by the military activities of China. We also seen the increase in the collision or almost collision in the air domain. Last year, the Pentagon issued a report and count almost in about 18 months, almost 300 incidents happened between Chinese aircraft and the aircraft of the US and its allies. The similarity situation happened in the East China Sea. Figure generated by Japan Ministry of Defense indicate the number of press release whenever there is an air scramble happen in the air zones of Japan, and indicate the increase in not only the number, but also it's more diverse in type of aircraft and more diverse in routes. We also see the expansion of the gray zone tactic in using warfare, using different type of activity to expand the maritime and sovereignty claim of China in both seas. The left-hand side map indicate the kind of spider web of all the pattern of the survey shape frequently used by China in the South China Sea. It is very important to note that the vessel used for maritime survey not only come from the state vessels, but also from the private sector. And March last year, China also expanded the plan to expand its survey activity across all the sea nearby, including the East China Sea. I exclude another map because it's not relevant to the topic, but also expand to Indian Ocean and Pacific Island. We also see in terms of like peaceful settlement, China is well known for its position of anti-judicial measures. For China, judicial measure equal to hostile activities. And July this year, China also again expressed its attitude toward the judicial measure in general and the arbitral award 2016 in particular. The Chinese Foreign Ministry spokesperson Wang Weibin say that he repeat again the old argument toward the tribunal award in saying that the arbitral tribunal violate the principle of state consent, exercise its jurisdiction ultravine, and render an award in disregard of the law. In fact, state consent is true, but the state consent has been given by China in advance when it's ratified UNCLOS in 1996, like Professor Takai mentioned in his presentation. Therefore, given the consent from China, the arbitral tribunal will have full jurisdiction to go ahead with the submission of the Philippines in accordance with its award on jurisdiction a year before the final award. But more importantly, the spokesperson of China also mentioned about several new arguments. The next argument, they say that many internationally authoritative law experts and scholars, including former president of International Court of Justice and former judge of the International Tribunal on the Law of the Sea, have written articles to point out the serious flaw in the award. So far, we haven't found one. Perhaps there's some piece of writing criticize the award, but most of them have the connection with Chinese scholar, and most of them is the very lengthy report made by the Society of Chinese International Law Society right after the award were issued. China also elaborated that China's position is not of not accepting or recognizing the Edward has won the support and understanding of more than 100 countries in the world. I try to seek the consent or the support from the other country, and so far hasn't received any confirmation or reaffirmation of the support from the other country for those 100 countries. And if you keen on learning the list of countries support the award, then perhaps you can visit the website of AMTCSIS. They also compiled a report on the support of the arbitral award, and it seemed like the tendency is increasing in favor of the award and in criticizing the position of China. Finally, the position of China in that caused a challenge for the international rules-based order perhaps is the use of its domestic law. The number of argument and information has been released about the law on safety of navigation, the law on Coast Guard. But in the presentation, I'd like to draw the focus on the law on foreign relations, because it's actually an attack on the rules-based order in the way that what I call is defensive and proactive. In the aspect of defensive, China, for the first time, declared its intention to take corresponding countermeasures and restrictive measures. And it's also planned to take law enforcement as well as judicial measures to protect its interests. Perhaps after the crisis in Ukraine, when see the state in the war collectively make counter-responding measures toward Russia, perhaps China is well prepared for its future in taking actively employ or implement countermeasure toward the other country. And what has been provided for the so-called judicial maritime area of China in both South China Sea and East China Sea, if you just look at the face, nothing wrong. But if you combine with the maritime claim and sovereignty claim of China, then it's almost cover everything in both seas. And you can see that if China going to take law enforcement, particularly in the law on Coast Guard, China plan to use the force and or authorize the Coast Guard to use the force in all the maritime zone under the jurisdiction of China, then it becomes dangerous. On the aspect of proactive, China committed to reform international order by introducing the 3Gs initiative, and it's believed that the current rules-based order is against the interest of majority, and therefore also on the one hand, China would like to promote a rule-based international order based on the UN system, but actually would like to go ahead with the new initiative, Global Security Initiative, Global Development Initiative, and Global Civilization Initiative. So in short, what we saw from the challenges happened in the South China Sea and the East China Sea. Perhaps we will go through the three main tendencies. The first tendency that quite popular and happened quite a long time ago is try to apply the cherry picking, try to arbitrarily interpret international law to serve one's own interests. But nowadays we start to see the new tendency that China denied the existence of the current legal order. And also the third one is moving forward to actively take lead in building the new rules. What are the new rules? We don't know yet, but perhaps it's not as on the benefit of the majority of the state in bordering the South China Sea and the East China Sea. And perhaps it will follow the cherry picking to serve one interest by using coercion and threaten the use of force. So with that, I would like to close my presentation here and looking forward for the Q&A section later on. Thank you.
Thank you very much, Professor Lan Anh. So we have just listened to two wonderful presentations which lay out very clearly the challenges that we face in the East China Sea and the South China Sea. Without being exhaustive, without trying to recreate that presentation, I couldn't recall that I hear at least the following challenges. First of all, China expansionism, but also militarism in both South China Sea and East China Sea. Secondly, major powers competition, and this represents in the heightening risk of collision, for example, in both East China Sea and South China Sea, but also in other possible challenges. We are also are concerned that the Ukraine-Russia war represents a new challenge, and that is the challenges presented by major powers disrespecting or disregarding international law altogether. We are also facing the challenges of hotspots, such as the hotspots across the Taiwan Strait, the territorial disputes in both East China Sea and South China Sea. But I think the greatest that both of the presenters spent on was the fact that China undertakes lawfare in both East China Sea and South China Sea. This is through unilateral interpretation of international law, or in many cases, arbitrarily interpreting international law, preventing criticisms from other countries with its behavior through diplomatic means, through wolf warrior diplomatic practices, and through domesticating its behavior through its domestic laws, such as law on foreign relations. If all these strategies are combined with misinformation or disinformation campaign, that is going to create a complexity, further complicate the challenges. We also touch upon the gray zones activities, both in East China Sea and South China Sea, for example, through the increasing use of civilian vessels, such as survey vessels, to attain strategic purposes. The gray zone activities, which blur the lines between military craft and commercial craft, blurring the line between peaceful means and the use of force, are increasingly deployed by China in order to advance its strategic interests, and that pose a severe challenge in both East China Sea and the South China Sea. So I think we have had a very good warm-up presentations. And now I would like to open up the floor to invite comments, questions from audience, both here in this room, but also online. The floor is open. Any question? Yes, Swimming, please. We have a lecturer from the DAV who would like to pose a question.
First of all, I would like to thank the two speakers, Professor Takai and Professor Lang, for a very interesting presentations. My questions concerning the concept of international law-based order. So both professors talking about international order based on law, or Professor Lang talk about international law-based order. But sometimes the other concept is quite popular in discussion about the South China Sea, the concept of rules-based order. So is there any difference in the meaning between international law-based order and rules-based order? Thank you.
Thank you very much, Ziming. I would collect one more question before turning it back to the presenters. Anyone would like to pose a question? Anyone online? Yes, Dr. Lan Hương, please.
Yes, first of all, I would like to thank both professors who share thoughtful presentations on the challenges of the rules-based or international law order in two China Seas. So my questions relating to I would like to ask you, could you share your perspective over the future reactions by China in case that in the presentations I hear that now China is more active and proactive in using the law as the tool. So in case in the future there is a new case law, so how would be the reactions of the China? So I would like to hear the maybe the predictions from both professor relating to the Chinese reactions. Thank you.
Thank you very much, Lan Hương. I believe there's one lady at the end of the table who would like to pose a question as well. Please.
Yes, thank you so much. I would like to give this question to Dr. Lan Anh, because in the later part of her speech, she has mentioned that China wants to build a new world order, a new law-based order. And in my thoughts now, I think that the law-based order now is a combination of the arrangement of the territories and the values that the US and the Western countries has agreed in the international law. So will China not only try to change the territories on the sea, but they also want to change the values? Can you give me some insights on the values that China will want to bring on the sea?
Thank you very much. So let me now turn over to Professor Susumu Takai and Professor Lan Anh to respond to the question. First of all, what's the difference between international law-based order and international rules-based order?
Well, perhaps I can go
私か
first.
ら、よろしいですか？高井です。はい。
May I? This is Takai speaking.
Yes, please go ahead.
ルールに基づいた
Rule-based order,
国際秩序と
rule-based order and international rule-based order. What is the difference? I think that was the question. The nature of the international law is that what has been agreed must be adhered to.
ですから今国内法であれば
So if it's a domestic law,
従わなきゃならないんですが、国際法の場合は
the situation is different, but international law, if you are against the law, you will not be in agreement of the law. And therefore, international law, a lot of time has been spent in order to build an international order based on international law. And that is what is meant by rule-based order.
少なくとも今日私
At least
中国も
what I mentioned today is that whether it be China or Russia, they're all both members of the United Nations, and they are have agreed with UNCLOS. And so international law-based order means that whether those countries are in adherence with the international law. May I go ahead?
2点目は
May I continue? And the
Please.
second point?
その行動
The second point was with regards to reaction of China.
非常に上手な
Well, China
としていましてですね
is taking a
で行動していて日本が反対
good,
すればそれを
shrewd approach, I would say, that if Japan reacts, China will pull back. But if Japan doesn't react strongly, China will pursue. That's what we've been seeing in the Senkaku Islands and other incidents in the East China Sea. That is how China is trying to exercise its sovereignty rights in the East China Sea. They're very shrewd in that, wise, should I say.
中国は両方とも
Japan and China are both
法があります
adhered to the common international convention, international law. And so that it works that way, especially Senkaku Islands. Japan is showing the grounds, the rationale that it belongs to Japan, but China is not showing international law-based rationale, but they're using ships of the Chinese Coast Guard and going into the territorial waters of Senkaku Islands and trying to go after Japanese fishing boats or Japanese patrol boats. I hope you understood me.
Thank you very much, Professor Lan Anh.
Well, international rules-based order or international law order have the common element of order. When you're looking for order, you need a rules, you need a law. And the law and the rules now are widely recognized as international law. And as I carefully identify the sources of international law, everyone nowadays, every state nowadays try to refer to the Article 38 of the ICC statute at the sources of international law. However, technically speaking, when you speak about a rules-based order, it's slightly broader than a law-based order, because perhaps rule will refer to the emerging state practice that not yet recognized as law. For the second questions, future reaction of China, especially the reaction toward case law. For the first part, I agree with Lan Huong that perhaps China is now very confident. It's used lawfare excellently. It tried to change the validity of international law via the domestic law. It tried to blur the value of the constitution of the ocean of UNCLOS by saying that there's so many flaws, there's so many weaknesses that states need to develop and build new rules in the future. But on the other hand, when it comes to judicial measures, it's kind of like a firm stand from China that is a hostile activity. And I don't think that it will change for the short term. Perhaps if there is a second case initiated by the Philippines, but China still walk out of the court and absent from the procedures. For the last question about the change of the order, what kind of values that China would offer to the world? Perhaps we need to distinguish between word and deed. China speaking very beautifully and usually refer to a beautiful value, beautiful sentence and words, and nothing against the value that China would like to offer to the world by all the 3G initiative. However, we need to look at the actual activities of China providing the world. When we come to the maritime domain, for example, China always try to emphasize the historical basics, which against the legal basics. China always advocate for the maritime Silk Road as part of the history and now try to build the common destiny at sea. The common destiny at sea is nothing wrong if it works for everyone, but perhaps it's only served for China and cause a lot of challenges and difficulties for countries who follow the maritime Silk Road at the moment. So perhaps if you just look at Chinese word, everyone can follow, but need to combine between Chinese word and deed.
Thank you very much, Professor. I believe that in my personal opinion, the international law-based order is a subset of an international rules-based order. It's a more specific subset of international rules-based. We have
Recording in
run out of
progress.
time for the first session. I would like to draw close to the session now. Without making a conclusion to the session, I'd like to thank the presenters for having contributed to this session and enlightening us and reminding us of the challenges that we are facing in East China Sea and South China Sea. And that opens up the topic for us to continue the discussion after the break, where we will discuss more on the measures to cope with the challenges and the way forward in order to maintain the international law-based order with the challenges that we have identified. So thank you again, and I invite you to take maybe a 5 to 7 minute break before we will resume at 15:15 for the second session. The webinar on the necessity of maintaining international law-based order in the East and South China Sea. We had a wonderful first session that discussed the challenges that is facing the South China Sea and East China Sea in maintaining the rules-based order. We have identified plenty of those challenges. Now on the second session, we are going to discuss how to cope with those challenges. And especially we will have the opportunity to discuss how to enhance collaborations between the countries in the region, especially between Vietnam and Japan, in order to tackle the challenges. On this second panel, we are very delighted to welcome Ms. Yurika Ishii, Associate Professor at the National Defense Academy of Japan. She is going to discuss the interpretation concerning military activities of UNCLOS Article 298. And we are also delighted to welcome Ambassador Nguyễn Thị Thanh Hà, former Vice General Secretary of Vietnam Society of International Law, who is going to discuss promotion of the rules-based order in our regional seas, taking toll of existing efforts to move forward. So let me now invite Ms. Yurika Ishii. Ms. Yurika, you have the floor.
Thank you so much. Thank you so much. So I'd like to start by thanking Mitsubishi UFG Research and Consulting and Diplomatic Academy of Vietnam for having me in this prestigious seminar. So we have heard two informative presentations in the first part of this seminar, and I'd like to focus on the dispute settlement mechanism that will enable the rules-based legal order at sea. So let me share my slide with you. So in the first part of my presentation, I'd like to talk a little bit about the compulsory dispute settlement mechanism that the UNCLOS provides, and especially explain what the Article 298(1)(b) means. Then I'd like to explore the development of the recent case law. So let me start with the explanation of the compulsory dispute settlement mechanism of the UNCLOS. So in the international society, there is no centralized authority above states. So courts and tribunals do not have their jurisdiction or their authority to try the case, basically without the consent of the defendant state. However, the UNCLOS introduced the compulsory procedure to overcome this limit. Article 286 provides that any dispute concerning the interpretation or application of the UNCLOS must be submitted to the court or tribunal having jurisdiction under the convention. Now, Article 287 introduces the mechanism for the member states to choose the forum of the judicial proceeding. Basically, a state can choose, the forum that they prefer from the following 4 forums: ITLOS, International Tribunal for the Law of the Sea, International Court of Justice, and an arbitral tribunal constituted in accordance with Annex 7. And plus, there's a special arbitral tribunal, right? Now, the problem is, how they decide the particular forum to decide on the dispute. In a nutshell, member states of UNCLOS need to take their case to court of tribunal agreed upon by both parties. So when state A chooses ICJ, state B chooses ICJ, then the forum would be the ICJ. Now, if they do not agree on the forum, So for instance, state A chooses ICJ, but state B chooses it lost, or state B does not make their choice, then the state must go to Annex 7 arbitral tribunal. So this is arbitral tribunal, so they can choose the judges sitting at the tribunal, and there's a particular procedure to enable the establishment of this institution. However, there's an exception to this procedure. Article 298 provides optional exceptions to this procedure. Member states can declare that it does not accept the jurisdiction with respect to the disputes concerning military activities, including military activities by government vessels and aircraft engaged in non-commercial service, and disputes concerning law enforcement activities in this regard to the exercise of sovereign rights or jurisdiction excluded from the jurisdiction of a court or tribunal under Article 297, paragraph 2 or 3. So basically, the Article 297 talks about the jurisdiction at the EEZ. So the nutshell is that if the dispute is about military activities, and if the defendant states have made the declaration that they do not accept the courts or tribunals' jurisdiction on the military activities, then the court or tribunal do not have the jurisdiction or their authority to try the case based on this clause. So in the Asian region, it is China, Republic of Korea, and Thailand that made this declaration that they do not accept the jurisdiction under this procedure concerning the military activities. Besides, Russia and Ukraine has also made the same declaration. So we have seen 3 cases that dealt with the interpretation of military activities under this clause. You can see the importance of the clause because we've heard a lot about disputes between China and neighboring countries. But if a country would like to bring the case before Annex 7 concerning those disputes, then they have to overcome this hurdle. They have to claim that the dispute is not about military activities. Otherwise, the tribunal would not have the jurisdiction. So when it comes to the South China Sea arbitration, in 2013, the Philippines, as we've heard about the case, the Philippines brought the case to Annex 7, a tribunal. However, because China has made the declaration concerning the reservation of the tribunal's jurisdiction on military activities, the tribunal had to say that the dispute was not about military activities when they tried to proceed to the merits. So there are several issues, 3 issues that Philippines has raised. The first issue concerned China's activities regarding the preservation of the living resources in the Philippines EEZ. From the Chinese perspective, it was the water within the 9-dash line, so-called. However, the tribunal decided, as you know, that the 9-dash line does not have the basis under UNCLOS, and it decided the area was a part of the Philippines EEZ. And the tribunal concluded that this exception, Article 298(1)(b), does not apply where a state is alleged to have violated the convention in respect of another state's EEZ. So this one's the first issue, which was not a big deal. The second one was more important. The second issue concerned the protection and preservation of the marine environment. The Philippines claimed that China's reclamation activities was a violation of the UNCLOS, and the tribunal had to look at the fact whether the reclamation activity was military activities as provided under Article 298. Now, when the tribunal decided on this issue, it looked at Chinese official statement that reclamation activities or installation and island building activities were not, of military nature. They were intended to fulfill civilian purposes. And therefore, tribunal decided that this was not a part of military activities. Lastly, the Philippines claimed that Chinese vessels' activities aggravated or extended the dispute by basically threatening the Philippines vessels in the disputed within the Philippines EEZ and the disputed basically it held that the Chinese vessel threatened the Philippines vessels by causing the standoff between the Chinese vessels and the Philippines Coast Guard vessels. And here, the court held first that this provision applies to disputes concerning military activities and not to military activities as such. So the tribunal considered the relevant question to be whether the dispute itself concerns military activities or not. And the court looked at the fact that the Coast Guard vessels of both states confronted with each other at the water, and the tribunal said that the essential facts at the second Thomas Shoal concerned the deployment of detachment of the Philippines Armed Forces that is engaged in a standoff with a combination of ships from China's Navy and China's Coast Guard and other government agencies. With concerning this dispute, the tribunal concluded that this was a part of military activities, and it held that it lacked jurisdiction to consider the Philippines submission. Now, next comes to the dispute concerning coastal state rights in the Black Sea, where Ukraine and Russia are the parties. So the case concerned whether Ukraine had, dispute over the maritime area surrounding, whether the Ukraine had rights over the maritime area surrounding a Crimean Peninsula, which Russia unilaterally annexed in 2014. Now, the tribunal declined to decide on disputes when it had to decide on the territorial issue because it is beyond the interpretation and application of the UNCLOS. However, beyond that point, the court had, held that it had jurisdiction to decide on the rights that the Ukraine or Russia might enjoy under the UNCLOS. Now, the court held several issues, but basically it said that the the physical force alleged by the Ukraine does not turn the dispute into one concerning military activities. Rather, the court has to held that it has to look the alleged force to appear to have been directed towards maintaining civilian activities such as the exploitation of hydrocarbons in fisheries. I will skip all the details, but the court looked at specific activities such as the detention of the captain of a Ukrainian fishing boat by Russian military personnel, the deployment of armed men to oversee the work carried out on an oil platform, the alleged harassment of Ukraine vessels by Russian military vessels, aircraft, and basically the tribunal said that those are not military activities and it has jurisdiction to try this case. Finally, the last one is quite important. It looked at the Russia's seizure of 3 naval vessels of Ukraine Navy in 2018. Now, of course, Ukraine claimed that it was a violation of international law, and it brought the case first to ITLOS to seek the provisional measures. And ITLOS held that it had jurisdiction, meaning that it was not a part of military activities. However, the ITLOS only looked at the prima facie jurisdiction. And after Russia released the vessels and crews back to Ukraine, Ukraine brought the case before Annex 7 tribunal, and the tribunal had to decide whether it has jurisdiction over this activity. So in this case, 3 Ukraine naval vessels was trying to go through the Kerch Strait, which is a part of the territorial sea of the Crimea Peninsula. Now, the ITLOS held that it has jurisdiction because the seizure was a part of the law enforcement activities. Now, the Annex 7 did not take the same approach, although it looked at the specific nature of the activity, which is the same approach of the ITLOS. And sorry, I will, for the time constraint, I will skip all the details. But the tribunal divided the event into 3 stages. The first phase involved the confrontation between military of 2 states, which the tribunal held that it was the military activities. The second phase started when the Ukraine vessels tried to arrest the Ukraine vessels. And the third phase commenced after the arrest of the Ukraine vessels and involves the continued detention of the vessels and their crews. The court held that the court had to look at in detail concerning the second phase, and it deferred the decision to the merits. It did not decide whether it was a part of military activities or not. And concerning the third phase, the tribunal said that it was not military activities and that the tribunal had jurisdiction. Okay, so I apologize for skipping all those slides. I assume that you have the file with you, so I hope that you have some time to see the text of the hours. So the key takeaways is that the concept of military activities is not well established. It differs from tribunal to tribunal and depending on the cases. Whether an objective evaluation of the nature of activities has to be made is questionable because although 3 Ukraine vessels took the affirmative position, the South China Sea looked at the Chinese government's officials' characterization of the activities. Now, the common approach is that the decision is to be made on certain specific acts rather than the dispute as a whole. Also, armed forces engagements in the standoff are likely to be characterized as military activities when you look at South China Sea and 3 Ukraine vessels. So this exception, Article 298, is to take the balance between the need to secure the peaceful settlement of disputes and the demand to secure state sovereignty in its discretion of the national security. So I think it is important that we keep an eye on the development of the case law. I apologize for speaking for too long. Thank you for your attention.
Thank you very much, Ms. Yurika Ishii, for taking us a journey through different cases that you take a look in depth at military activities and it's how it is seen by certain judicial bodies. And this has drawn you to the conclusions which I will need the help of legal experts to make more sense and to further discuss in the subsequent session. Let me now invite Ambassador Nguyễn Thị Thanh Hà to provide your views on promoting the rules-based order. Please, Ambassador.
Thank you very much. Good afternoon to everyone. I think Vietnam and Japan are coastal states of very busy and important seas, namely the East China Sea and the South China Sea. And both countries attach great significance to the maintenance of peace, stability for their development in these seas. So I thank the Diplomatic Academy of Vietnam and the Mitsubishi JFJ Research and Consulting Company for taking the initiative to organize this exchange of views. We have listened to presentations on obstacles and challenges to peace and stability in the two seas. These sadly have been there for many years. So how we go about to deal with such a situation? On my part today, I would like to raise two questions and try to give you the answer from my own perspective. The first question would be, do we have a good law-based order to promote in our two regional seas? My answer is affirmative. Yes, we have a very comprehensive and proactive rule-based order. First of all, we have to mention the universal legal order provided by the UNCLOS, or the Convention on the Law of the Sea of the United Nations, which is also called the Constitution for the Sea and the Ocean. These conventions provide the legal criteria for states to determine and exercise jurisdiction at sea. It also provides frameworks for cooperation in the uses, management, and protection of the sea, including its ecosystem, marine resources, and the facilities and structures established by states at sea. It provides principles and procedures for peaceful settlement of disputes relating to the interpretation and application of the convention. What is most important is that all coastal states in our two regional seas are members to the UNCLOS. Not only they are bound by all the provisions of the UNCLOS, they regularly reiterate their determination to respect and implement the convention. Second, we have to mention that countries in our regions have adopted many regional legal or political instruments and engaged in high-level dialogues to manage the escalation of disputes and to promote cooperative schemes at sea. To name a few, we have the rules for vessels navigating through the Straits of Malacca, sponsored by the IMO. We have the Regional Cooperation Agreement on Combating Piracy and Armed Robbery Against Ships in Asia, RECAP. We also have the Declaration on the Conduct of Parties in the South China Sea, or the DOC, and we have the ongoing discussions toward a code of conduct between China and the ASEAN member states. We have the Code for Unplanned Encounters at Sea. And among many high-level meetings every year, I have to mention the Japan-ASEAN Annual Senior Officials Meetings on Transnational Crime, and the MOU between ASEAN and China for cooperation in non-traditional security. Third, bilaterally, many agreements on maritime boundary delimitation have been concluded between coastal states in our region, which help reducing disputes in the overlapping areas. In some of the overlapping areas where delimitation is pending, joint development of resources have been carried out, such as the Joint Development Agreement between Japan and Korea in the southern part of their continental shelf since 1974, or the MOU between Vietnam and Malaysia for joint development of petroleum in the overlapped continental shelf between the two countries since 1992. In general, these legal and political instruments and forums have been working well, keeping our regional seas free from armed conflicts for at least the last recent decades. Territorial and jurisdictional disputes do occasionally arise, but most of them have been checked through negotiations or resorting to the judiciary procedures. For the first time in 2016, the Arbitral Tribunal under Annex 7 of the UNCLOS was established and delivered judgment on some of the maritime jurisdictional disputes in the South China Sea between China and the Philippines. Although the 2016 arbitral judgment is binding on only China and the Philippines, but it has profound implications on clarifying the legal basis for maritime entitlements of coastal states in the South China Sea and beyond. And the second question I would raise is how we move forward to ensure peace and stability and development in our seas. This is surely too big a question for me to introduce a complete answer. So I only would try to share with you a few ideas prompted from my legal background. First, I think we must continue with all efforts to promote and respect the legal instruments, whether it is multilateral or regional or bilateral, because these we have voluntarily adhered to. This is our treaty obligation. It is no hidden fact that multilateral instruments such as the UNCLOS contain provisions which are unclear or do not meet one's expectation due to compromises made during the negotiating process. So in the interpretation and implementation of these instruments, states are required to show goodwill and respect the law of treaty. Even if a state wishes to improve or to change the meaning of the provisions of the UNCLOS, for example, that must be done by diplomacy and persuasion, not by coercion or the use of force. Second, we need to be more proactive in negotiating legal texts aimed at controlling the use or the threat to use force, the escalation of disputes to armed confrontation, such as the Code of Conduct of Parties in the South China Sea, which is being negotiated. And third, more attention and efforts should be given to the cooperative arrangements to deal with untraditional threats to security, like the sea level rise, the climate change. Because if we cannot deal effectively with these risks, they may soon endanger the livelihood of many coastal communities of our countries. I thank you for your attention.
Thank you very much, Ambassador Nguyễn Thị Thanh Hà, for taking stock of a quite long list of instruments that we have managed to build to maintain good order and the rules-based order at sea, and for your suggestions on how we can move forward. So we have listened to a very wonderful presentation, and now it's time to open up the floor and come up with more suggestions and to discuss these recommendations put forward by the presenters. The floor is open. We have about 15 minutes left, so I encourage you to come forward. Any questions, suggestions? Yes, Dr. Lan Hương, please.
Yes, I can. I will take the chance to have the question directly to Dr. Ihiki. Because I'm very interested in the nature of military activities, because this term is not defined clearly in the UNCLOS. And you mentioned 3 cases explaining what is the military activities. And one of the takeaway I heard from your presentation relating to we need to have an objective evaluation of the nature of the activities and taking the relevant circumstances. And when I heard the previous presentation relating to the maritime military activities in the East China Sea and the South China Sea. So my question is, could you share your viewpoint? What is the nature of the maritime military activities in the 2 seas? We can see that a kind of military activities or a law enforcement activities. Thank you.
Thank you very much, Dr. Lan Hương. Any other question? Yes, Ngọc Anh, please.
First of all, I would like to give many thanks for the presentation from Ms. Thanh Ha. And I have a question about which alternative procedure parties should use if the dispute falls in the optional exception related to military activity under Article 298. Thank you.
Thank you, Ngọc Anh. Any other question? Yes, there is a hand on the second row behind. Vân, please.
Thank you very much, our speakers today for their very insightful presentations. With regard to this particular session of the workshop, which deals with the issue of how we can move forward to take advantage of to cope with the challenges that both seas are facing. I just wonder whether the speakers, either Mrs. Thanh Ha or Ms. Chi, has any idea on any particular area that countries bordering both seas can carry out together. For example, if you raise the issue of sea level rise, climate change, or any suggestion or proposal for emerging issues like marine plastic pollution, for example, if you can share with us your thoughts. elaborate more on the cooperation ideas on the model on how countries in the two seas can cooperate with each other to cope with the challenges that has been put forward. Thank you.
Thank you, Ms. Wen. Well, maybe I should add a question myself. And this question goes to Ms. Yurika Ishii. Having studied very closely military activities in both East China Sea, South China Sea, and other parts of the world, could you enlighten us on the kind of complications, legal complications we would have or would need to be prepared for should a military conflict erupt in the Taiwan, across the Taiwan Strait, something that countries in the region is very concerned of? So we have 4 questions from the audience. Would Ambassador Ha or Ms. Yurika would like to take up any of those?
I'm happy to start. Thank you for so many important questions. The first one concerning the action of maritime militia, whether those activities done by the maritime militia are military activities provided under Article 298. It's an important and difficult question because the nature of the maritime militia has to be decided. Now, I think we have to look at what actually the maritime militia is doing. It could be a part of the law enforcement activities, or surveillance, or the support of Chinese Coast Guard vessels. I think if those activities are evaluated as non-military activities, including the military law enforcement activities, then the court will decide that it is not part of the military activities. Also, if you look at the South China Sea arbitration case, the characterization of the Chinese government of the maritime militia would matter. Now, it doesn't have to be Chinese government. It could be any government, but the characterization of the government matters in deciding whether it is a maritime, the military activities. However, if it involves the standoff between navies or Coast Guard vessels, then it is likely, in the case if the maritime militia is involved in the standoff or confrontation between those agencies, then it is likely that the activities could constitute a part of the military activities. Now, concerning the second question, if I heard correctly, the question was what option that do the parties have if the court decides it is military activities. So the short answer is that if it is a part of military activities and the defendant states that it does not accept jurisdiction over such activities, then the parties do not have the option to go through the judicial proceeding. So it has to rely on the diplomacy and other non-judicial dispute settlement mechanisms. Now, concerning the third question, which is also an important one, I think there are so many areas that countries can cooperate, and especially when it comes to the issues concerning the common interests of the states. It is easier to cooperate. So you raised a number of examples. I think those are the ones those are topics that countries can collaborate on. However, when it comes to the dispute of maritime area or territorial disputes, it is hard to settle down. So I think it is important that we adhere to the rule-based order. The territorial title and maritime titles are decided based on international law. So I think we should, negotiate based on those established rules and norms. And also, it is important that we adhere the obligation to peacefully settle the disputes, which is a part of the United Nations Charter and UNCLOS. Concerning the fourth issue, I think it really depends on the nature of the disputes. You mentioned the case of Taiwan crisis. I doubt that whether it constitutes the disputes concerning the interpretation and application of the UNCLOS, because for a number of reasons. And when it comes to the military actions on land, then obviously the court does not have the jurisdiction over the case. Taiwan is not a party to the convention, so the case that is plausible is whether when Taiwan crisis occurs and China and other member states of the UNCLOS come into the dispute at sea. So as long as it is not a standoff situation, then it is possible that the court holds that the action is not military activities as provided under Article 298. But however, we have to look at the actual case, whether it constitutes the standoff between the militaries, and we have to also look at other elements that I provided in the presentation. I hope that it would be that will provide some answer to your questions. Thank you so much.
Thank you very much. And Ambassador Nguyễn Thanh Hà, please.
I think I have to answer two questions. And the first question is about the options of states to settle the disputes relating to military activities when one of the parties has made the declaration to exclude it from the application of obligatory procedures. And my answer is the same with my panelist, my co-panelist. In that case, then we still have the negotiations, which is always a very good way of peaceful settlement of disputes. And we also can apply those unobligatory procedures, such as asking for advisory opinion of the court, which is half political and half juridical. About the question on how in our two regional, how we can cooperate with Japan and other partners in our regional seas to deal with emerging threats. I think we have right now a mechanism of cooperation among the ASEAN member states. And I think the most difficulty we are facing is the lack of fund. So I think this is where Japan can come into the picture. We can try to get the financial assistance from Japan, and also with that assistance, we can get the technical assistance from other international organizations and try to operate the cooperative schemes, which are being discussed for many years already among ASEAN member states. Thank you.
Thank you very much, Ambassador. I think we have about 2 minutes left. Any other question? Any further questions that we may have from both the online audience and participants here? Well, everybody seems to be very happy with the discussion. So I think we will draw the close to the second session of today's webinar here. I think we have had a very fruitful 2 sessions to discuss both the challenges and also the means to and the ways to tackle those challenges. I think we have had a good discussion on this second session. We have understood that the international rules systems is very fragile, and there's a constant need to raise the awareness about its fragility and the need to coordinate actions among, like Susumu-san said, like-minded countries in order to uphold the international rules-based order. We heard that there are many challenges in interpretation of the existing international legal system, especially UNCLOS, in order to protect the rules-based order. But if there is a goodwill, like Ambassador Ha said, and there's a good observation of the law of the treaty, I think countries can uphold the integrity of the UN UNCLOS and apply it to properly manage disputes and maintain good order at sea. We also need to, as Ambassador Ha suggested, we need to invest more and negotiate more and put more negotiation into negotiating text like the Code of Conduct on the South China Sea. And we also need to take more attention, pay more attention in order to address rising non-traditional threats like sea level rise and climate change. But I think after all, this webinar highlighted the need to have more dialogues and more collaborations between middle powers, so to say, like Japan and Vietnam, because these countries will be fundamental in the strengthening of the international rule-based order, because as discussed in the first panel, most of the challenges are stemming from the unilateralism and arbitrarianism taken by the major powers. And this is not just coming from China alone. So that highlighted the need for the other countries in the international system to step up and step in to provide the cooperation, much needed cooperation to uphold the international rules-based order. So I would like to once again thank the 4 speakers of today's webinar. I'd like to thank all of you for participating, both here and online. And I would like to again thank the Mitsubishi UFG Research and Consulting Corporations, which co-partners with the Diplomatic Academy Vietnam in hosting this webinar. And we look forward to welcoming you to more participate in future seminars held by the Diplomatic Academy of Vietnam. And to Professor Susumu-san, I would like to thank you. I hope that we will see each other again physically sooner than later.
Yes.
Thank you
very
so much. Thank you. Also to
yes,
Professor.
Yes, of course. I hope so too. Yeah, thank you very much indeed.
Thank you. Also to Ms. Yuruka Ishii, looking forward to seeing you in person, maybe hopefully next time when we hold the next webinar. Thank you very much. And we have a webinar feedback form, which is on screen. If you can kindly take a screenshot and give us a feedback on how we can do better next time. Thank you so much.